Liability for sport organization in the diagnosis and treatment of concussion. The perception of head injuries in sport has undergone a sea change with advancement in research of traumatic brain injuries and related long-term effects, galvanized by headline-making stories including recollection of former players of the debilitating symptoms they live with. Public attention has also been drawn by litigation commenced against sport organizations, teams, and even manufacturers of the sporting equipment. As a result, the conversation is rapidly shifting from whether there is a link between injuries to the head suffered in sport and long-term health effects to what should be done to protect players and how an organization can address liability if they fail to adequately do so. The science and the law surrounding concussion and other brain injuries in sport is still evolving. Lawsuits against the NFL, the NCAA, and NHL have settled before going to trial. There is no definitive case in Canadian law clarifying exactly when, how, and to what extent a sport organization might be liable for head injuries suffered by its players. However, existing law provides some guidance to protect how sport organizations might be held liable and, more importantly, what steps can be taken to limit that risk. In this article, we will focus on the law of negligence and look at each of its elements in turn to identify areas where an organization can take steps to limit its risk. Liability of a sport organization for negligence requires proof of three basic elements. There was a duty of care owed to the injured party by the organization failed to meet the requisite standard of care, and there was a probable loss resulting from that failure. Duty of care. Given the role most sport organizations play in regulating the conduct of the game, including setting and implementing safety protocols, detailing the rules of the game, and monitoring player conduct, there is little debate that, in most instances, sport organizations will owe a duty of care to players. This has already been accepted by multiple courts in Canada. Standard of care. The more difficult question, however, is what steps must be taken by sport organizations to satisfy this duty. The law has regularly recognized that the standard of care owed is a reflection of the surrounding circumstance. In the context of sport, players are presumed to accept and consent to the inherent risk of playing sport. In other words, a player may not be able to sue for injuries suffered in the regular course of competing in a sport, even if they would have been able to in other circumstances. The standard of care owed will vary depending on the type of sport and its inherent risk. Participants in sporting activities where there is a foreseeable risk of harm are presumed to have accepted the risk of incidental harm in the course of play and to waive any related claim. The foreseeability of risk varies by sport. Football is different from basketball, which is different from golf. The assessment of what fits within the scope of accepted risk will vary depending on the nature of the game, the degree of competitiveness, the level of skill, and even more contextual factors such as the conduct of the parties at the time the injury occurred. While participants are presumed to have waived liability for injuries that fall within the normal course of a sporting event, this waiver may not cover liability for injuries suffered as a result of aggravated or intentional conduct. This is an important distinction for assessing liability, as brain injuries suffered during the regular rigors of a game will be treated differently from injuries resulting from premeditated or predatory hits that run counter to the rules of the game or the training provided. Whether brain injuries fall within the scope of inherent risk in a sporting activity remains unclear at law. The issue of what sports organizations or teams knew about brain injuries in the past and how such injuries were treated sat at the heart of litigation filed against the NFL, NHL, and NCAA. However, The settlement reached on those respective matters means the court hasn't issued decision on those questions. Furthermore, even if the court had provided clarity, the fact remained the issues in those proceedings were about injuries suffered in the past. Thank you.